Welcome, everyone. This is Jackie Hale, and we are here today to review and discuss an article that was recently published by the Chronicle of the Horse on January the 28th. It's written by Molly Bailey, entitled USCF and the U.S. Center for Safe Sport Answer Your Safe Sport Questions. It's very informative. It's a question and answer session with the United States Equestrian Federation, which of course is the national governing body for equestrians, and the U.S. Center for Safe Sport. We are going to focus on only the safe sport questions and the answers provided by Scott Lewis, who is the acting Chief of Response and Resolution at the U.S. Center for Safe Sport. Joining me today is Shane Darnell of the Equine Sports Council and Horse Show Wire, Jean Lopez of Sugar Land, Texas, who is an award-winning Taekwondo athlete and coach, and Tamron Tucker, who has been with us before. She practices law in Virginia and South Carolina. I'm going to pass the mic to Shane now to introduce our guests.
Thank you, Jackie. And I just want to thank the Horse Chronicle for publishing that article. It was very informative. And we're doing this just to as a follow-up based on what has been experienced over the last year through the safe sport practice. And again, I want to thank also Jean Lopez for reaching out to us, and then also Tamara for joining us again for another podcast. So I'm going to pass the mic to Jean, let him introduce himself and tell us about his famous family.
Well, thank you for having me. I am a four-time Olympic coach. I have been involved with Taekwondo for about 36, 37 years now. I've had the most successful program, local team. It's been one of the most successful programs ever in the United States. I've been the national team coach from 2006 through 2016, but started my national team coaching career in 2001, and I have coached at 4 Olympics, 2004, 2008, 2012, and 2016. My family is regarded as the first family of Taekwondo. They all made the Olympic team in 2008, and where I coached them in Beijing, all to medals. My brother Mark Lopez is a silver medalist. My sister Diana is a bronze medalist. And my brother is a 3-time Olympic medalist, winning 2 golds and a bronze. My brother Stephen is also a 5-time world champion, was undefeated for 10 years, have lots of programs. I've had lots of programs nationwide and done seminars all over the world, and engage with different Olympic committees in consulting them on how to develop their Olympic programming.
Thank you, Jean. And Tamara, I'm going to pass the mic to you.
Okay. I'm Tamron Tucker. As Jackie said, I'm an attorney in Virginia and South Carolina. Primarily practice in the area of civil litigation. Part of our firm's practice is employment law, and in that context, we handle Title IX cases, sexual assault cases in the tort context, and other types of employment-related matters. I also have a niche practice in equine law, where I handle safe sport cases, USEF administrative cases, and other, contract fraud types of cases. One of the things that I just want to say sort of before we start off is that looking and going through this safe sport process, which is relatively new, I think from my perspective, having practiced in the litigation context for 25 years, I see some parts of the process that Safe Sport has implemented that could be improved. And I think that what can be perceived as perhaps criticism by me and some other attorneys really would be viewed better as constructive feedback that I think will lead to a process that the membership that is subject to these safe sport rules will think is fair and will perceive it as fair. In the Title IX context, one of the most important things about investigations that schools handle in sexual misconduct or sexual assault cases is that the investigative process have integrity. And that's important not only for the accused, or in the safe sport context, the responding party, but it's important for the reporting party as well. Because if the public in general doesn't view this process as having integrity or as being fair, they aren't going to believe in the results. And that's not fair to either party to have their name, whether it's the responding party, their name published, and then people figure out who the reporting party is, to have at the end of the process people not believe what the outcome of the investigation was is detrimental and really undermines safe sports mission and the mission that Congress set out for it. So I just want to sort of frame our responses today, and pretty much in any other podcast I do, as coming within that framework.
Great, thank you. Well said. And I'm going to pass back to Jackie. She's going to moderate this podcast and help us get through these questions and answers on the article that was recently published.
Okay, so starting with question number 1, does everyone who is reported to the U.S. Center for Safe Sport get investigated? Tamra, can you take that one?
Sure. Obviously, safe sport, Mr. Lewis is in the best position to know in terms of what percentages of cases they investigate and don't investigate. I think the answer that he gave maybe requires a little bit of clarification. He stated that there's some reports they don't pursue that he would call low-end abuse. Tommy called Sally a bad name, and he said that they refer those to the national governing body. I just want to make clear that sexual misconduct cases are handled by Safe Sport. The other cases, bullying, harassment, emotional abuse, are handled by USEF. So it isn't whether it's low-end abuse or high-end abuse. That isn't the distinction between which process you go through. It's the type of allegations, whether it's sexual misconduct or other allegations.
Okay, then we'll move on to number 2. What standard of proof is required in safe sport investigations?
Mr. Lewis answered that it was the preponderance of the evidence is the standard of proof, which is correct. That is the standard of proof that Safe Sport uses. I think maybe he misspoke when he said it's the same standard as that the law uses. So that's a little bit incomplete and maybe needs to be clarified. It depends on, in the real world, what context you're in, what standard of proof is applied. So, sexual assault would be litigated primarily or possibly in the criminal context, and that standard of proof would be beyond a reasonable doubt. If it's a sexual assault case that is litigated through the civil process, in the employment context, perhaps, then the standard of proof is preponderance of the evidence. But what's important to remember is that in a civil court, even if your burden of proof or standard of proof is preponderance of the evidence, which is generally sort of like, does it tip the scales beyond 50-50? We always use the tip the scales analogy. We have discovery in that process in civil court, and there are standards for admissibility of evidence. So a court, whether it's a judge or a jury, cannot consider hearsay type of evidence or other double hearsay, other types of evidence that might not pass the normal admissibility threshold. And the reason for that is those are safeguards on a process, on a legal process, to ensure that the evidence is tested and found worthy before it is considered by a decision maker. So when you combine that with a lower preponderance of the evidence standard, there's still some safeguards. In the safe sport context, we're using a lower standard of proof, preponderance of the evidence, and we don't have those safeguards in terms of discovery finding out, the responding party finding out all of the information. And we don't have the safeguard of admissibility for evidence. There's no threshold. They can consider hearsay. They can consider that, Tommy heard from Sally that heard from so-and-so. Whatever the case may be, they can consider that evidence. And so I think it's important to remember that we're dealing with a lower standard of proof than the criminal context. And we're dealing with a lower standard of proof combined with a lack of safeguards that we have in a civil proceeding.
Interesting.
Okay. Question number 3. At what point in the investigation does the accused get full information about his or her accusations? So we're going to jump over to Jean so he can share with us his experience.
Right. So initially, when I started getting investigated, I really I didn't know who were the reporting parties were. I had no idea what the allegations were. The only time that I got some kind of idea of what was going on was when the investigators from SACEport asked me if I would be willing to participate and be part of the process. I was going in there with good faith, thinking that that I'm going to get a fair opportunity to say my part, and being able to was looking forward to be able to defend any false accusations being made against me. And what ended up happening through that investigation was nothing short but feeling that the investigators and SACEport had already had in mind that they were gonna ban me. The interview was hostile, and it was even in the interview, it was very generic. They didn't give me any specific or times or place as to when the allegations and the false accusations were taking place. I didn't know who the people were. They referred them by initials. AF said that she heard from TL that this happened sometime between 1997 and 2010. I'm giving you kind of an example of the kind of questions that the investigators were asking me. I felt I couldn't defend myself on those things. It was set up for failure, in my opinion. It was set up to find me guilty of whatever accusations that were being made. Then fast forward, what happened? SACEport then came up with a decision, but I didn't hear the decision from SACEport. It was already blasted on USA Today, and it was presented as if SACEport had, SACEport was presenting itself like they charged me of something criminally when all they did was go off their one-side investigation, very incomplete investigation as it turns out, and basically made a decision to ban me from being able to coach. And like I mentioned earlier, I didn't find out from SACEport. I found out from USA Today. It was printed on, it was printed all over the papers that, Olympic coach has been banned indefinitely for the accusations that the reporting parties were making against me.
And Jean, this is Shane. When you said earlier you couldn't defend yourself, that was because the vague situation they were explaining to you, you had no idea what they were talking about. You couldn't figure out what they were talking about, and so you had no answers. Is that what you're saying? That's exactly
what I was trying to say. That it was so vague. that I didn't know how to even respond, to the questions. Some of, the questions, were really graphic in nature. Have you ever been involved in, pretty graphic things that they would add on to that? But then kept, the names and the people and the places and the times, and just completely general. It went so far to say, have you ever had sex, from 1997 through 2005? It was ridiculous like that, and it got to a point where I had to go, well, if are we talking about my sexual history, or is there an allegation? Or what's the accusation? And they wouldn't answer my questions.
Tamron, do you have anything to add from a legal perspective with regard to that?
I do. This is probably, I think, the biggest sticking point that lawyers are experiencing with regard to helping their clients through this process. And it is, Mr. Lewis's answer is 100% correct. They choose what information to give to a responding party. They cherry pick that information. In some cases, it's been very vague. And they, in some lawyers' experience, also have sort of offered to give more information as a carrot. Well, if you do this, then we will give you more information. And Mr. Lewis's answer admits just that. He says that, if the respondent is participating in and cooperating with the investigation, they are privy to almost everything. So, two things. One, that's not true, because people have cooperated and still not gotten all of the information. And two, that is not the way this should work, at least in my opinion. And I would say that this sort of falls into the constructive feedback I was talking about. This is a bad idea, to withhold information intentionally, not let someone have a meaningful opportunity to respond. And that's a legal phrase that has meaning. And then to make a decision based on the information that you have withheld and not allowed somebody to respond to. That's an approach, more of a law enforcement approach, I would say, in a criminal context. And even in that context, you get some discovery. But I don't see the point, and I don't see how it fulfills the mission of Safe Sport to approach their investigations this way. I don't think people, as they learn, I don't think the membership is going to support this type of investigation. It strikes Americans in our gut as fundamentally unfair. Of course, we should be able to have the allegations and information presented to us so we can respond to it. That's just pretty axiomatic, sort of liberty types of concepts. And, I'm not sure what the reasoning is behind this. I understand maybe protecting identities of witnesses. There's, a competing interest where you want people to be able to come forward and feel comfortable. I understand that. But there is a way to provide adequate information to a responding party so they can defend themselves while still protecting people. And I don't think that is being done, and that balance is being struck right now in the appropriate way. And I think at some point, this particular part of the process will come under scrutiny in a court.
Okay, we're going to take the next two questions sort of in tandem. How are sanctions determined? What warrants a permanent ban versus a 2-month ban versus something else? And number 5, what are the criteria for banning someone for life? Can you be sanctioned for something that's not illegal?
On this one, I think it's important to remember that the factors that go into determining appropriate sanctions are set forth in Safe Sport's own policies and procedure. So there shouldn't really be too much of a mystery about what those factors are. And I'll run through them really quickly. There's 8. The first is the seriousness of the violation, and Mr. Lewis mentioned that, which makes perfect sense. How serious is the conduct at issue? The second is the responding party's prior history. And again, Mr. Lewis alluded to that when he talked about, is this allegation 25 years old, and then the person hasn't had any complaints since. You're looking at, is this an isolated incident, really? I think is probably the way to characterize that factor. The third is the ages of the individuals involved. Are we talking about 2 adults in their 30s? Are we talking about 2 kids that are 16? Are we talking about an adult in his 40s who is accused by a 15-year-old, student or athlete? That's important, and I think that factor makes perfect sense. The fourth is whether the responding party poses an ongoing threat to the safety of others. So this kind of falls into that current fitness that we talk about, whether if this person does not pose an ongoing threat, if there was a determination that this was an isolated incident between maybe 2 people who were in a relationship at one point in time, and there's never been a risk of harm, no reports that the responding party has engaged in any other type of inappropriate behavior or any other type of sexual misconduct, that should be an important factor. And I would say, especially when you're determining the fate of someone in sport who makes their living from that sport. The fifth factor is voluntary disclosure of the offense and/or cooperation by the responding party. This goes back to the first podcast where we talked about the adverse inference and the Fifth Amendment sort of implications there. In this case, what this factor is saying is, did you completely stonewall our investigation? If you actually engaged in the alleged misconduct, did you just own up to it? Did you just say, yes, that's what happened and I'm sorry? That would be part and parcel of that factor. The cooperation piece of it, I would say beauty is in the eye of the beholder, and so is cooperation. You're at the mercy as a responding party as to what level of cooperation the decision makers at Safe Sport deem appropriate. The sixth factor is disposition of an investigation by state or federal law authorities. They don't say criminal, but that's sort of implied in there. Was there a criminal investigation and what was the outcome? Seventh factor is the real or perceived impact of the incident on the reporting party, the NGB or the USOC. That kind of falls within that reputation of sport that we talked about in the last podcast, in addition to whatever impact the reporting party has talked about with the investigator. Is this a person who has, had to go into counseling, who has been diagnosed with PTSD perhaps following, an alleged act of sexual assault? Those are the types of things that we also see in, quote, the real world in civil cases that we handle. I would say in the constructive feedback piece of this, when you talk about the impact on the NGB and the USOC, part of that impact is going to come from how the case is publicized, whether you publicize it before the investigation, after the investigation, what and how you disclose. Those types of things actually can maybe have a bigger impact than the alleged misconduct itself. And then the eighth factor is sort of the catch-all factor, other mitigating and aggravating circumstances that, kind of leaves it probably to your discretion or to Safe Sport's discretion, sort of the gut reaction as to what feels warranted in terms of a sanction in this case.
Okay, thank you. We're going to jump back over to Jean for the next question. What is the process of an investigation? Jean, can you tell us a little bit about your experience?
Right. So basically, went through like I had mentioned earlier, a very hostile situation with the investigators from Safe Sport. They then went on to decide. They made a decision that they felt that they believed the accusers, and then I got the Safe Sport came up with the decision to ban me indefinitely, without again what I felt basic due process. Found out through the newspapers that Safe Sport had banned me, and it went everywhere. I mean that because I'm one of the most renowned coaches in the country and in the world, it made huge news everywhere. It was devastating to read Safe Sport's decision in a newspaper in USA Today, and devastating for my family and everyone. To hear the news that way, but also because the perception from people is that when they hear that Safe Sport has made a decision, they don't understand that we haven't had our opportunity to defend ourselves. I was just merely going through the process of, or the lack of process of, what Safe Sport had asked me, to participate in, and I was looking forward to being able to, defend myself. But everyone took the news as if I was guilty of the things that I was being alleged, and that's simply not true. Safe Sport makes a decision based on again a very incomplete, one-sided investigation, very biased. Then it took me a while to get to a point where I can get a fair hearing, and the only time that I really did get a hearing, a fair one, was initially at a point where we're ready to take it to JAMS, which is the independent arbitration company that Safe Sport is bound by. Safe Sport came back and said that they were not ready to take their case to arbitration. So Safe Sport stayed their decision, lifted my ban, so I was able to coach again. But then the national governing body decided to continue independently, continue with the ban. So it didn't do anything for me as far as being able to finally get my career going forward again and getting everything behind me, because the NGB was upholding their own independent ban. Then it forced me to take Safe Sport to arbitration to expedite it, because they were not respecting the stayed decision from Safe Sport. So I went through the arbitration process finally, and then Safe Sport, or the arbitrator found that Safe Sport had no evidence against me and the allegations that were made. So the arbitrator made a decision to vacate Safe Sport's decision and allow me to coach immediately and get off the Safe Sport ban list. But unfortunately, my national governing body, USA Taekwondo, is not adhering to that. They're not respecting the arbitrator's decision, and maintains my ban on the USAT side, and I'm listed there with everyone else that has some who have been criminally charged, and so it's been completely damaging to my reputation and my family's.
Jean, it's Shane. Can you summarize financially what the impact has been to your business, and also what you've had to pay in legal fees just to get through that process?
Sure. before I answer that question, I want everyone to know and that after I went to the arbitration, I found out that the accusers had already spoken to SafeSport, and their lawyers had contacted SafeSport that the accusers were not going to participate in the arbitration back in February of last year, and SafeSport knew it this whole time that they were not going to participate and not going to be part of the process. And in spite of that, SafeSport still continued with their ban, and they ended up not being part of the process of SafeSport. They were not part of the investigation. It's completely. It turns out to be incomplete. In some cases, the most time that they dedicated to one of the accusers was about 10 minutes. It was just horrendous, to find out all this information finally when I got my opportunity to defend myself in arbitration. Going back to the damage that's done to my family and myself. First, the emotional part of it has been so hard on my parents, on my brothers, my sister, my friends, my children. It's been devastating to read in the newspapers that SafeSport has. The media has ran with it and said, we're guilty of these things, and which it turned out to be not true. But in our sport, everything is based on, our reputation. We've had a stellar reputation. I've taught and coached thousands and thousands of kids and females and males all over the world, and these allegations go back, from 1997 through 2003, and the severe toll that's taken on us financially has been catastrophic. And I'm not being dramatic. It's cost us hundreds of thousands of dollars to defend ourselves, and I can't even tell you financially, real income money. I can tell you that's been hundreds of thousands of dollars that have dried up from not being able to work in our business that we took a lifetime to be able to build up. I've had taekwondo schools that I've had to, disassociate myself with, programs that I've had to shut down, camps that I can no longer give, seminars that I can no longer give. It just goes on. And there were a lot of business projects that Stephen and I were working on that we've had to put on hold. The damage that's been done to us, I feel, is irreparable financially, and the emotional part has been one of the toughest for us to face.
Would you say if you had to throw a dollar figure at it, you're probably at about $500,000 loss at this point, or greater?
I think it's more than that. It's more than that. But the projected, the damage that's done to our potential earning is for a lifetime.
What's that? Yeah.
Yeah.
I just want to follow on to Jean's comment about the cost imposed in getting through the SafeSport process, particularly in getting to an arbitrator, because it really isn't until you get to an arbitrator that people have found that you get more information and that you can adequately really respond to what you're being accused of. And I think that the cost, in addition, setting aside the legal fees, which is huge, if SafeSport finds against you, you have to pay $5,200 for the arbitrator just to get heard. And while $5,200 in the context of tens or hundreds of thousands of legal fees might not be a lot of money, that is a fairly high entrance fee for review by an arbitrator, especially having gone through a process where, by its own admission, you aren't being given all of the information. I mean, SafeSport has said we don't give responding parties all of the information. So you go through this, which Jean adequately described as a one-sided process, that's incomplete and that potentially withholds information. You get a final decision, and if you're the responding party or the reporting party, you don't like the decision. In order to have it reviewed, you have to pony up $5,200 right off the bat. And where that potentially fits in legally, that I've been thinking a lot about, is there's a long history of arbitration cases where arbitration first became favored, especially in the employment context, and you signed away your rights to sue as an employee and said, I will arbitrate. And early on in the process, in these cases, the fees that an employee had to pony up were fairly stiff. And challenges were brought against those arbitration provisions based on what we call unconscionability. And unconscionability means that a court looks at it and says, that is so fundamentally unfair that it really undermines the purpose of this contract. And it shocks the conscience. It isn't right. To me, this particular provision, this part of the process, smacks of unconscionability. And although there is a hardship exemption, so if you say, I don't have $5,200 to pay the arbitrator, SafeSport can review it and say, oh, we'll grant you a hardship exemption and you don't have to pay that. But there's not a lot of criteria or precedent for what constitutes a hardship exemption. The hardship exemption has come up in a case that I know about, and the response was pretty ad hoc, I would say, by the director of SafeSport, and kind of the thinking behind how they were going to apply this exemption was pretty nonsensical. So I think that two things. One, I think the $5,200 is probably subject and ripe for challenge at some point when someone can't afford access and they're going to lose their business because they've gone through this process and they can't pony up the $5,200 to get an arbitrator to review it. And two, I think the hardship exemption needs to be spelled out better. There needs to be criteria that people know about, people understand. They know what they're signing up for when they agree to be USEF members and be bound by this process of SafeSport. So that's sort of my comment from a legal perspective on the cost. And of course, the catastrophic costs really come from the legal fees and the loss of business opportunity for those who make their living in a sport.
Thank you both. Moving on to the next question. Why doesn't the list of SafeSport sanctions include detailed information about violations?
Well, obviously, SafeSport's in the best position to answer what they do and do not put on their website about violations. But this kind of falls again under that bad idea, constructive feedback. I think allegations of sexual misconduct, that makes sense. I think getting into details when your process is not a criminal process and you've not found someone guilty beyond a reasonable doubt, you've not had to go through the evidentiary process I talked about earlier, where evidence is deemed admissible by a judge, based on tests that we have as lawyers. So I think when you've gone through this sort of lower burden, loosey-goosey kind of process to determine whether somebody has violated the SafeSport code or not, going on to then put in sort of salacious details on a website is probably a really, really bad idea. And I certainly hope that SafeSport does not do that.
Moving on to number 8, how are third-party investigations different from first-party reports?
To me, the process for SafeSport, when they get a third-party report is probably, it's tougher for them. I know Mr. Lewis says right in here that, it's going to take, it requires more work for their intake people. And I would say it probably also requires another layer of work for the investigator as well. One of the studies have shown that one of the indicators for potentially false reporting is when a third party makes a report based on something they've heard or something that's even been told or confided to them. So I think that probably just adds, sort of they need to put their antenna up a little bit more when they get a third party report and make sure that they investigate it more fully. But other than that, I don't know that the process itself really differs, at least for the responding party.
Jean, did you have any experience with that during your investigation process?
Well, I felt that in my case, I felt that third-party reporting was weighed heavily in Safe Sports' initial investigation, and I just think that's completely unfair from all aspects. But let's just say, let me create a scenario for you. I don't like that coach. I don't like him because I think he competes with me, and he's vying for a spot for the Olympics, and I want him eradicated from the selection process of being an Olympic coach. We're both competing for the position to be Olympic coach in 2020. I tell one of my athletes to report anonymously to Safe Sport that he or she found out that he did something inappropriate with someone else, that she had heard from somebody else that coach had been inappropriate, and basically you from a third party reporting and the way that I've seen Safe Sport deal with my investigation, that you can totally weaponize Safe Sport to eliminate your competition, eliminate people that you may have, an axe to grind with. So that's again, I'm not a lawyer, but from a logic standpoint and from understanding basic civil liberties and rights, I feel that it's completely wrong, and it feels like we're living in a time, and Safe Sport is like a product of this, of our times, that it goes back to the 50s when you would call out somebody for being communist, and that's all you needed to do to get that person in prison. Or, back in the Salem witch trials, that if they were jealous of you or they didn't like you, that they would say that you were a witch, and then that's all they needed to prosecute you. So that's why that's exactly what Stephen and I have experienced. And so when it comes to third-party reporting and even false accusations, I feel that Safe Sport has failed not only the victims, true victims, but also did not take in mind basic civil liberties and that they put in their mechanisms in place to be able to protect those who have been falsely accused, like Stephen and I have been.
Okay, and moving on to the last question, how does the U.S. Center for Safe Sport handle relationships with an imbalance of power between consenting adults?
Jackie, my comment on this particular issue, I guess, would be this is an important issue for Safe Sport to handle. I mean, to me, this is one of sort of the core issues, or the core impetus behind Safe Sport, behind Congress taking action on this, which is the imbalance of power when you've got an Olympic coach and people vying for places on an Olympic team, and the coach has leverage over young people where they can exploit them, they can exploit that leverage to perhaps engage in sexual misconduct. So I think that this is a really important issue. I think it's tough, and I think what USEF membership is grappling with is that, going back to my last podcast, this is the square peg in the round hole phenomenon. So USEF membership is, I think, 50,000 at this point in time, owners, trainers, riders. And very, very few are part of the Olympic team, the Olympic movement. I mean, it's a little fraction at the very top of the sport. And our sport's a little bit different than some of the other sports because of that. We just have this huge umbrella of people that span, the whole country, span all levels of riding. We have owners that are members simply because they own a horse, but they haven't sat on a horse or even been to a horse show in a really long time. So I think that that's something that people are really struggling with. And I think that goes back to my initial comment, which is it's really important that membership have trust in this process. And when they don't, they get upset and they get angry and they feel like it's unfair and they feel like they don't want to be part of the United States Equestrian Federation. And, one of the good things about our membership being so large and having this huge umbrella is that we are able to support the sport with dues and other types of, monetary assistance. And we're just able to support the sport as a whole. We feel like we're part of the sport, even though I'm never going to ride on the Olympic team. I root for the Olympic team, and I want to be a part of the sport in general, and I think that that's important. But people don't want to be a part of it when they feel like there's a process that is unfair, one-sided, and doing damage to their friends, to their trainers, to their loved ones in the sport. So I think that that's something that we really have to wrestle with, and we really have to make sure that our leaders in the sport and the folks running Safe Sport understand that USEF membership is different, bigger, and would like to see something that they can rely on and believe in, and that will allow them to continue to be a part of the sport.
On that question, Jean, in Taekwondo, what is do you know what our membership numbers are about 150,000. It's what's being reported to us. What is the membership base in Taekwondo, and then how does it work as far as your members? Are they required to do Safe Sport?
Right. So we have, and this is an estimate, around 14 to 20,000 members that are registered under USA Taekwondo, which is the NGB, the official NGB for under the United States Olympic Committee umbrella. But there are millions of practitioners of Taekwondo, nationwide. There's a Taekwondo school basically in every corner. But only those who are participating in want to participate in USA Taekwondo sanctioned events have to become members, and all the members then have to go through the process of Safe Sport and going through their training and everything that they have involved. But if you're not, if you don't want to participate in, the Olympics or in the Olympic movement, then you're not required to be a USA Taekwondo member.
Interesting. So, yeah, and we're being told on our side that even if we're not involved in the Olympics, it's now a federal law that we have to do the Safe Sport Olympic movement process. But I know it's not the case, and we're seeing it's not the case with other national governing bodies.
Yeah, I think that's BS. In my part, if I wanted to teach Taekwondo to opened the school, I don't know why I need to be governed by USA Taekwondo to tell me how I need to teach, what curriculum to teach or how to teach it. I mean, that's my business, and I think that's the fair way of looking at it. I think it's BS to have to force every person that does Taekwondo under USA Taekwondo, even though from a monetary standpoint, it would be very beneficial for USA Taekwondo for membership and things like that. But I don't think it's fair.
And one of the things that people need to remember is that it isn't a matter of there's a void that Safe Sport was filling. There are legal remedies that we already have in the real world. So in the Taekwondo example, if Jean went out and opened a Taekwondo school and wasn't a member of US Taekwondo, and did something, sexually assaulted someone, we have a remedy for that. You can go to the police and report it. They will investigate it. They will prosecute it. We also have civil remedies for this type of conduct as well. So it isn't as though you have to bring everybody under the Olympic umbrella in order for there to be a remedy for someone who is a victim. We have remedies already in the world for that.
Exactly.
Thank you both for being with us today and sharing your perspectives. Jean, thank you for sharing your very personal experience with us. We know that you have not discussed this publicly much, and we appreciate you being willing to come forward and tell your Safe Sport experience and how it has affected you and your family. Tamra, thank you again for your expertise. You always share very practical, no-nonsense advice. For our listeners, the Equine Sports Council in no way condones sexual misconduct or the abuse of any child, nor do we endorse the guilt or innocence of any featured athlete or coach. We do, however, support the return of fair governance in amateur sports and due process. If you would like to help us, please sign the congressional petition to restructure USOC, the NGBs, and Safe Sport. It can be found on our website, equinesportscouncil.org. Thank you.